So my name is Heather Potter. I am an associate attorney at Gardner Law. I am also a certified information privacy professional with a focus in the European privacy law. And today I'll be giving the update on US privacy, primarily looking at the trends that we've seen, some interesting case studies that have come up, and also briefly talking about California privacy just for a quick moment. So I'll let Oliver introduce himself if he'd like to before we get started.
Thank you, Heather. Yes. Hi, good morning, everyone. My name is Oliver Sümme. I'm a partner at the European law firm Fiat Fischer. I'm based in Germany. And when Heather has completed her part, I'm happy to provide you with an update about the latest developments in terms of European data protection law and the GDPR.
Great. All right. Okay, so here's our agenda. I'll start with just giving a quick sort of overview on what both myself and Oliver will be talking about, kind of why it's important. So in the US, privacy is a statutory obligation, whereas in the OUS, such as Europe, it is a fundamental right that also has broad statutory obligations. So there are global companies who have customers and in both the US and OUS that now have individuals who have different rights with regard to their privacy. So this has become a bigger topic of late with GDPR, and as well as just the more advancements in tech and device and pharma companies wanting to be more integrated with patient care. So what we have seen come up is as companies start to implement their GDPR privacy program, instead of taking more of a geographic approach to privacy, more companies are trying to take a more holistic and enterprise approach to it. So looking at all the applicable privacy laws that apply versus in silos. So we've seen that as a trend is coming up more and more. And as Oliver will discuss, it's looking at, it's getting a little bit more complicated, and what we have to look at and consider for different citizens and how we reconcile that where there are differences. So this is just a quick list of the US privacy laws. We're only going to talk about HIPAA and high tech today. So HIPAA is the Health Insurance Portability and Accountability Act, and it was designed to protect patient information. HIPAA applies to covered entities and business associates and essentially regulates how they can use and disclose PHI. And in short, you can't use or disclose it unless an exception applies or you have patient authorization. So we're going to talk through those two things today, just how a lot of manufacturers interact with customers where they're not where the manufacturer is not regulated by HIPAA, but the customer is. It creates a lot of confusion. There's always similar questions that come up across the board about, do we sign BAAs? Do we not? So it's a very unique law, and that it's not often well understood even by the individuals that it regulates. So I'm going to cover some definitions to start with, so we can get those out of the way and you know what I'm talking about for the rest of the presentation. I'll start with, this is quick, just OCR enforces HIPAA, and they impose civil monetary penalties against individuals who violate it, which vary in degree depending on knowledge. These were just recently updated, so you can see those there. Okay, so now I will get into the definitions. So the first one I'll cover is protected health information and what that is. So there's the list here. It's a number of identifiers that relate to an individual's past, present, or future health care. And this protected health information is the information that's generated or kept or stored by a covered entity. So a lot of times in for manufacturers, we sort of use this phrase PHI just to mean, sensitive health information, sensitive patient information, not necessarily protected health information under HIPAA, unless, of course, HIPAA applies. So it's important to understand sort of what the HIPAA definition is versus how, as a company, you're defining PHI and why you're defining it in that way. If your intent is truly to follow HIPAA requirements as far as categorizing what is considered PHI, that's one thing versus if you just kind of generally refer to it as PHI. It can create some confusion, and I've seen that come up a few times where it's individuals like, well, I just have the patient's name, like I know it's not PHI, but it's their name on their X-ray, and it's like, well, it's from the covered entity, so that is PHI, but let's take a look at how you got that and what you're doing with it. The next definition I will go over is what a covered entity is. So a covered entity is a health plan, a healthcare clearinghouse, or a healthcare provider who's transmitting healthcare information in connection with a covered transaction. So for manufacturers, typically you're not considered a covered entity unless you're doing an activity that meets the definition. But your customers, so the physicians and the hospitals and the clinics, the pharmacies, those are covered entities. Those are individuals and facilities that have to comply with HIPAA. So it's important to be aware, where you're going to have a customer who's really following these rules and trying to comply with these rules, so that you can make sure that you're meeting that and still continue business with those companies. The next definition I'll go over is a clearinghouse. What is a clearinghouse? This comes up this and the covered entity in the next definition of a business associate. These come up a lot with regards to the applicability of the treatment, payment, and healthcare operations exception. So a clearinghouse is, the definition's right there. It's a facility that, processes transactions on behalf of from one entity to another. So clearinghouses are covered entity, HIPAA applies, and whether a manufacturer is a clearinghouse, it really depends on the activity. And I have this note here about, will you be in the future? And the same goes for the definitions of covered entity as well. If you look long-term at the activities that you as a business are hoping to implement, the next 2-5 years, if any of those cause you to become one of these regulated definitions, that's really important to know, because then you can plan for it. The business associate is a definition and an issue that comes up I think at minimum once or twice a week. I have this conversation all the time, because it's really confusing for manufacturers, because a lot of manufacturers are exposed to a lot of PHI, and it's not clear necessarily who they're performing a service for. So a business associate is an entity that performs a service on behalf and requires PHI to perform that service on behalf of the covered entity. So it's situations where like your manufacturer is providing a reimbursement hub, where this question comes up. Are we supporting the facility, or are we supporting the patient? And what are we doing with this information? So whether what the activity you're doing is what will define whether you're a business associate. And we have seen, just as I noted, companies being a lot more progressive and forward thinking as far as how they interact and reach out to patients, as well as healthcare providers, and the ability to use data in order to provide value to those individuals, which creates a lot of gray areas and questions about whether the company is a business associate in those activities. So it would be recommended as a forward-looking initiative to know if you plan to do those types of activities, maybe start to comply with the business associate requirements. We see a number of companies doing that now. That allows them to be able to sort of flip the switch, so to speak, once they start a business plan that causes them to be a business associate. That way, you know, kind of day one, they have the infrastructure set up to support meeting the obligations under the rule. The last definition I'll go over is data breach. I bring this up because a lot of times we get panicked calls and emails from clients who maybe have received PHI from a physician, either pursuant to a valid patient auth, let's say for like on a reimbursement form or form for reimbursement support, and the manufacturer, the individual accidentally sends it to the wrong fax number or the wrong email. And we get these panic calls like, we have a data breach, what do we do? What do we do? How do we report this? You know, like, do we have to like publicly announce this? And, you know, the analysis depends. If you're a business associate, then we need to follow HIPAA, but typically most manufacturers are not BAs. So it's more of following what would be required for breach investigation without necessarily being subject to the notification requirements. So we counsel clients to, you know, investigate the breach, you know, investigate the disclosure, try and recall the message, try and ensure its destruction, you know, retrain and reach out to the physician to let them know what happened, and then document all of this internally. That's typically the method that we address with that, but we often have to kind of calm people down and just say, okay, yes, we've had an incident here, but we're not, you know, we're not regulated by HIPAA. Your covered entity is, so they may have some obligations, so let's provide them with the information they might need to report that. I'm just waiting for my slide to go there. Sorry, just waiting for my slide to advance. There we go. Okay, so I'm going to go into the exceptions. So typically after I've had the conversation with the client about how HIPAA does or doesn't apply to them, and typically it's that it doesn't directly, but it applies to their customers, we get into more fact-specific scenarios about how can we get the information we need to fulfill our regulatory obligations. And under HIPAA, there is it's known as the public health exception or the FDA exception, which allows the disclosure of PHI for use in manufacturers who are regulated by FDA. So this would be for instances that relate to quality, safety, or effectiveness of that regulated device. So think about complaint reporting, MDRs, vigilance, device tracking, recalls, sort of anything in that area of FDA regulation. That's where this exception applies. It's very narrow. I have some people like to get creative and say that, you know, their patient education is related to safety and effectiveness, and R&D is related to safety and effectiveness, and you're not wrong. But if we look at this definition and this exception, it is very narrow, and it would be wise to follow it as narrowly as possible. And where maybe you think that those activities fit under, but it's not clear, execute a patient auth, you know, find another legal way to obtain that information versus trying to make sure that it's covered under here. And it's a lot of times we're seeing manufacturers taking on the responsibility of determining if this applies. It's technically the covered entity's responsibility, but we like to make manufacturers aware of what these are and how they work, because sometimes covered entities aren't even sure. They're not sure if they can disclose the information. Maybe they're super scared to, or their compliance advisors advise them not to. It all depends. So it's important to we educate clients on these exceptions with the knowledge that it's for their own peace of mind versus necessarily complying with HIPAA or the requirements. The next exception that comes up a lot is the TPO exception. That is the treatment, payment, and healthcare operations exception. That allows a covered entity to disclose PHI without a patient authorization for treatment, payment, and healthcare operation activities. So they can disclose it to other covered entities, other healthcare providers. As long as it's covered under those three categories, they can disclose it without having to obtain a patient auth. There are some minimum necessary requirements depending on what the activity is, but in some instances there aren't any. And consent, as typical under HIPAA, it's voluntary. So you'll see some customers like to just get the okay from the patient to have the rep in the room, and that's totally fine. It's just it's not a required activity. So HHS, why this comes up a lot with manufacturers, and particularly with device manufacturers, is because a lot of times you're in the room or you're interacting with the patient directly or with the physician. So it's this question, and a lot of clinics or facilities will ask you to sign a BAA before a business associate agreement before you can be in the OR. And we get in these unique positions where the manufacturer is not a business associate, so what do we do? So HHS FAQ 490 is a great resource, and in that FAQ, HHS said that a device company meets the privacy rules definition of a healthcare provider if it's furnishing, billing, or is being paid for healthcare in the normal course of business. Now, a common misconception is that now suddenly the medical device manufacturer is now a covered entity under HIPAA, when in fact what we're looking at is a very narrow exception for the covered entity to disclose this information during their treatment of a patient. It's not, doesn't suddenly cause the med device manufacturer to be a covered entity. So healthcare under the privacy rule means care, services, or supplies related to the health of an individual. And you'll see in these examples, the key factor that I look at when I'm determining if the TPO exception is applicable is the individual and uniqueness piece. So if you're talking about an arrangement where you're selling your appropriately labeled product and you want to give general advice to physicians about XYZ, and you want them to disclose PHI for that, that is not a TPO exception. That's selling your appropriately labeled device, educating a physician. What the TPO exception contemplates is very unique and time limited interactions between a med device rep and the covered entity, where the covered entity is asking the rep, can you help educate this patient on how to use their device? Can you assist me in determining the right size for this implant? Can you be in the OR in order to provide technical services? These are very limited in duration activities, and they're related to a specific individual, that individual that's on the table, that individual that's in the room. It's very, very limited and very narrow. So similar to the public health exception, very narrow. And if the idea is, excuse me, if the idea is that maybe you can get away with meeting this exception and not needing a patient auth or not needing consent, and it's not really clear, just best to interpret this as narrowly as possible in order to ensure that you're obtaining information in the correct way and not putting the customer in a compromising position, but you're also ensuring patients' privacy. The other piece that comes up under the TPO exception. We see this both for med device and pharma, because a lot of companies offer rebates or, pricing assistance, things like that. And that would be under that payment portion of the exception. So that allows the covered entity to disclose PHI in order for a manufacturer to adjudicate claims that are submitted pursuant to a rebate contract. Okay.
Heather, we just received
Yes.
a question.
Okay.
So where does the FDA exception exist in the regulatory? Is one question. Or
So,
exists in the regulation, sorry, CFR.
oh, if I don't have it on the slide, I can put it on the slide. Oh, it's 45 CFR 164.512 B13. I can go back to that. So that's where that's in the exception, or in the rule, in the actual CFR. Just click back so you can see that. And then the TPO, so 45 right down here, 45 CFR 164.512, public health exception. And then TPO exception, I've got that in here too. Sorry, the slides just take a minute. Okay, maybe I don't. I can put that CFR in there, but it's in the same 45 CFR in that same chapter where they're talking about exceptions. I think it might be C. It's in that same area of the regulation.
Okay. So, and then I have another question here. When I hear patient, I think of the classic health provider / patient relationship. So how does a subject in, for example, a clinical trial meet the definition of a patient?
Sure. So in a clinical trial, excuse me, typically in that process where you're going through informed consent, patients are signing a patient authorization that allows their treating physician, which would be the site leader, the site physician, they're accepting and agreeing to be in this clinical trial. So they often sign patient authorization in order to allow the site to release data to the company or the sponsor of the trial. So it's still kind of your standard patient-physician relationship in a clinical trial, but you do have a little bit more documentation up front as far as like, we know we're collecting your data and we're going to use it for this purpose, and here's the patient off. I hope that answers the question. If not, let me know.
Okay, that's all for now. Thank you.
Okay, yep. So just to summarize these exceptions, again, when they apply, that allows the covered entity to disclose the PHI without the valid patient auth. And just remember that these are very narrow. And typically a business associate agreement is not required either unless your activity is providing a service on behalf of the covered entity. So in those situations, maybe you're able to access PHI or receive PHI under an exception, but your activity and use of the PHI might be a business associate type relationship. The next question I get to after I've explained that is, what about the PHI we get under the TPO exception? What can we do with that? Can we use that for marketing, for patient education? We already have it. And the answer is no. The TPO exception is narrow. If you want to collect that information to use for those other purposes, we recommend obtaining patient consent, like directly from the patient, and obtaining that information from them, or getting a patient auth executed. And again, this is a requirement on the covered entity for them to comply with. But we see in industry, almost across the board, companies generate patient authorization forms that are specific to their device and their activities and provide that to physicians to provide to patients and then keep on record. So it's more so that the company knows and has peace of mind that information they're getting is they can actually receive, and there's no kind of unlawfulness about it, not necessarily on their part, but on the part of the physician. Okay, so this is just a slide of considerations. I think I know that information is very valuable, and its input into a company's current and future state is just unmeasurable. It's so important, but I do try and push back a little bit when I have a client say, we want to collect and use everything. We want everything, all the device data, every record of them, being in the office and things like that. And my question is usually, how much do you really need PHI to achieve whatever your goal is? Can you get away with de-identified information? Or if you do need it, how much do you actually need? Do you need, their name and their social, or do you just need their name? So really trying to trim down and narrow to the minimum necessary that as a company you need to achieve your purpose. It's then also considering if you can get information directly from the patient. So if we're not interacting and obtaining information from a covered entity, we're outside of HIPAA. And if we're working directly with a patient, and the patient says, here's my name, here's my health information, like I have this condition, that's not PHI. It's not PHI under HIPAA. So that's always another avenue depending on the situation. So I'm going to go through a couple areas where we've seen, violations, and I use that term loosely. And I've mentioned a number of these. For example, the reimbursement support hub. I alluded to, who is the service being provided to? So a lot of times when these are set up, they're set up as a service for the patient and not the customer. But one of the issues that I see often is in the creation of marketing collateral for sales to use with physicians, as they sort of frame it as this, customer support, and that in fact actually makes it look more like a business associate arrangement, and it also implicates the anti-kickback statute. The other area that comes up, and it's surprising how much it comes up, is with marketing collateral containing PHI, specifically with speaker bureau decks where physicians are adding in their own cases. So in review, because those are sponsored, so ad promo boards review those. We'll see, CNAs or X-rays with PHI still on it. We'll see case studies with derivatives of PHI. And as a company, to try and limit risk, we'd always request that be covered or removed in some way. And the last one I'll touch on here is the smart devices. So that's any device that's like just constantly generating data. In the omnibus rule, it talks about how, like a pacemaker, for example, just by its very nature of generating data that data is not necessarily PHI. It is once it meets the definition, right, which is kind of vague. So, I've been through this exercise with a number of clients about when, the client has the information, it's on their server. Can they just go in there and collect it and use it for XYZ purposes? So again, depends on what they're pulling out and the purpose of their doing. It's very fact dependent scenario. And it's not something I recommend waiting to the last minute to investigate. It is, I think, at inception, let's think about that, because then you can implement controls if you wanted to just get de-identified information out of the system to process for your purposes. All right, that's just the recent OCR actions. Those have not changed in the last 3 years. They've been the same areas of concern. This is just, I'll wrap it up quickly because I know I'm going over a little bit. This is just kind of the list of what it really takes to be a business associate, the list of policies and procedures. And as I mentioned, we've had clients sort of reach this tipping point where they are choosing to comply with these requirements and implement safeguards, because in future state, they do plan to be a business associate. And once they get there, they can just automatically sign agreements from day one, and they have the security mechanisms in place and the policies and procedures in place. Okay, so just for a takeaway about HIPAA, it's to protect patient information. And so the idea that, because HIPAA doesn't apply to you, doesn't mean you shouldn't not protect patient information. As you'll see, there are state statutes that go beyond HIPAA that would capture this information. So it is a best practice to have a privacy program that complies with HIPAA. All right, I'll do 2 minutes, 1 minute on CCPA, Oliver, and then I'll hand it over to you. Just this enforcement just began in July of this year, which is why I thought it was important to bring this up. 2 of the questions that I've gotten related to CCPA and med device are the HIPAA carve-out and the clinical trial carve-out. So HIPAA carve-out is pretty straightforward in that if you're a VA or a covered entity and you protect patient information, which would be personal information under CCPA in the same way that you protect PHI, then you meet this exception. The area that gets a little tricky is not all information that you have is necessarily PHI. So it's really important, and it can then be burdensome to try and protect that information in the same way that you do PHI. So the best thing to do is to data map to identify those streams of information, and then create a plan as to how you're going to comply with HIPAA and or meet CCPA requirements. The last one, this clinical trial carve out, just very quickly, it's really unclear and vague, and it's created a lot more questions than I think it has answers. You can read it as requiring a clinical trial to comply with the federal policy for the protection of human subjects and one of those other 2 listed rules, and that creates problems because that might actually not allow privately funded research to be exempted, because you could have a privately funded research that's only covered under FDA, not necessarily another one of those clinical trial subject rights. So lost control of my mouse again. The next slide is an recent enforcement action, but I'm going to skip over that for now and just kind of get to the summary slide quickly so I can hand it over to Oliver. Ultimately with privacy, you need to say what you do, and you need to do what you say. It is so much more than just putting a privacy policy in place and putting a program in place. You need to audit, monitor, train, ensure you have controls, and continually implement privacy by design into all your business processes. It's a lot. It's an initiative. It's more than just the website privacy policy. There's active enforcement here. Oliver's going to talk about that with GDPR. There's active enforcement here in the US. And there's just greater focus on privacy in general, not only from regulators, but we've seen an increase in companies being motivated to address this because of inquiries from investors and board of directors, as well as strategics. And then lastly, the general public is becoming more knowledgeable and aware that their privacy and their information might not be as secure, and that is concerning. So it can also, potentially create, kind of competitive advantage if you are able to, provide security measures beyond what's necessarily required of you, whereas your competitors might not. So ultimately, protect patient information the best way that you can, and think critically about how HIPAA does or doesn't apply, and what state laws do or don't apply.
Heather, we have another question that arrived. Okay. Are the requirements different if the patient is a minor?
I don't believe so. And in that case, there would be a legal guardian or a representative that would sign on their behalf or, make decisions on their behalf. I can't think of anything off the top of my head, and hasn't really come up for me in that situation. But that's the first thing that I would think that I think of is that the patient's parent or guardian would be responsible for interacting with respect to disclosing that patient's information.
Thank you.
Mm-hmm. All right. Well, if there's aren't any more questions, I'll hand it over to Oliver. Thanks for letting me steal a couple minutes, Oliver.
Thank you, Heather. Great, good. Then let's jump to the other side of the pond, actually. And let me start to bring you up to speed with regard to the latest developments in Europe in terms of GDPR and data protection. The first thing maybe that's worth mentioning, because it's not explicitly in my sites, is that, as many of you will be aware of, the definition of personal data under European law is by far broader than what Heather just presented with regard to protected health information. Under the GDPR, almost every information that might be indirectly related to a natural person can be considered as personal. So it's much broader by definition. And that leads to situations where some authorities even would consider an X-ray without the name of the patient as personal information, because it's such a unique picture that it, at least from a theoretical perspective, could be referred to a certain patient or a certain natural person. And that's maybe a good example for one of the fundamental differences that we have under European data protection laws compared to the regulatory framework in the US. Good. So with that as a precondition, let's jump into the recent developments. And one development that you might have followed is the latest verdict of the European Court of Justice, the so-called Schrems II decision. Why Schrems? Why Schrems II? Because the man behind this case is an NGO founder, Max Schrems, so it's just his name, and he already brought another case to the European Court of Justice that was the so-called Schrems I decision, and now we have to deal with Schrems II. And Schrems II, as you might know, dealt with the validity of the so-called privacy shield. And in order to understand that, it's important to know that under the GDPR, you not only need, of course, a legal justification for the processing of personal data, personal information, but as soon as you would transfer such information abroad to third-party countries like the US or like any other country outside the European Economic Area, you would need another legal ground, a legal justification for doing so. And the so-called privacy shield was one of the most important legal grounds for transferring data specifically to the US. The basis of that was a political agreement between the European Commission and the US administration. And in this very recent decision, the ECJ invalidated this adequacy decision with regard to the privacy shield, and basically, killed it, and with immediate effect said that this legal ground is not valid anymore. And we have, I think, around 5,000 companies that relied on this privacy shield as a legal ground. So you can imagine that for a lot of companies, that was a very disadvantaging decision, and they had to look within very short notice for another legal ground. The interesting thing about this Schrems II decision is that the ECJ also referred to another very important legal ground, and those are the so-called standard contractual clauses. The European Commission has approved a set of standard contracts for third country data transfer, and these are the so-called standard contractual clauses. And the ECJ basically pointed out that these standard contractual clauses remain valid. That is the most important information, but, and this is quite a pretty big but, under certain conditions. And that's what we will speak about a little later. Before we do so, you see on this slide in the second bullet point the main reasons why the ECJ came to the conclusion that the privacy shield would not be valid anymore. Because as you see on this slide, it does not limit the data collection to what is strictly necessary. In particular, personal data processing activities carried out under certain US laws, namely Section 702 of the Foreign Intelligence Surveillance Act and the so-called Executive Order 12333. And those are the US laws or provisions that have explicitly referred to by the ECJ. And this way of surveillance, in the view of the ECJ, is not proportionate and thus does not comply with European privacy standards. So that's the key justification for this verdict. It was interesting to see that more or less immediately after this verdict, we saw a number of European authorities that provided some, well, initial guidance. In some cases, it hasn't even been guidance, but more a first statement. And I have put some of these statements and initial guidance on the slides here. You see statements from Germany, the UK, and also some information from the French authority, the so-called CNIL. The one that you see on the top of this slide is probably the most strictest one that we saw. That is from the German Federal Commissioner for Data Protection, saying that now special safeguards have to be taken for the data exchange with the US. Companies and authorities can no longer transfer data on the basis of the privacy shield. Excuse me, now this is not the strictest one, that is more a general one. There is one that is not on this slide from a Berlin-based local authority that says after this verdict, every kind of personal information has to be kept in Europe and might not be transferred to the US anymore, regardless of the legal justification. So if you should ever read this, please keep in mind that that is really a very strict view and interpretation of this verdict, which is not shared by many authorities. The UK Information Commissioner's Office, the so-called ICO, stated that the CGEU has confirmed how EU standards of data protection must travel with the data when it goes overseas, which means this judgment has wider implications than just the invalidation of the privacy shield, and that already refers to potential additional measures that you need to put in place if you rely on the standard contractual clauses. And then we saw also a statement from the French Commission, the so-called CNIL, but this one is specifically referred to a European health data hub that is operated by Microsoft, and the French authorities were of the opinion that this is not a basis anymore for transferring health data from the European Economic Area to the US. But it's important to know that the French Administrative Supreme Court did not share that view and basically disagreed. So this is just the statement of an authority, which not necessarily means it's binding. I think this is, by the way, an important difference to guidance of US authorities as well. Everything I refer to in terms of guidance in my presentation is not binding. That is recommendations and views of authorities. And we see a lot of cases where the judges have different opinions on that, which must not necessarily be in line with any guidance of European data protection authorities. As you might know, we have all these national authorities in the EU, but we also do have a European Data Protection Board, which is the centralized umbrella European Data Protection Authority, which also made a statement, and very soon after this verdict published a catalog of frequently asked questions on their website. And you see the key statement here on this slide, which says whether or not you can transfer personal data on the basis of standard contractual clauses. That's what's really interesting here. Will depend on the result of your assessment, taking into account the circumstances of the transfers and supplementary measures you could put in place. The supplementary measures, along with the standard contractual clauses, would have to ensure that US laws does not impinge on an adequate level of protection they guarantee. And that is really the challenging thing here, because it's quite tricky to think about potential supplementary measures that you could add to the standard contractual clauses that, well, would put you in a position to minimize the risk of data monitoring by US enforcement or surveillance authorities. How should that work, right? That's a very good question, and this question has not been answered yet. We have seen some first careful guidance of authorities, and I'm just copying some potential supplementary measures that might suffice here on the slide as well. So one of that could be to use more technical protection for data that are transferred to US. First and foremost, encryption on transit and on rest, of course. That is something that is very important. You could also take care for the shortest deletion periods possible for the certain data processing. And you could also put in place certain authorization requirements for access to the data that you transfer from Europe to the US. This is just some, well, initial potential measures that might or might not be accepted by the authorities. We are in a, well, pretty uncertain situation currently, because we have not seen any final guidance from neither local authorities or the European Data Protection Board in terms of what you really need to put in place in order to comply with this Schrems II verdict of the ECJ. The good news, however, is that the European Commission announced that within the next week, they will come up with a new set of standard contractual clauses that take this verdict into account. I'm not able to tell you an exact date, but most people I'm speaking to expect these new standard contractual clauses to become up by the end of the year. But this will also only be the beginning of a process, because it's the start of a consultation. This will be a draft, and then the Commission opens up a consultation process together with the industry, together with European authorities, in order to develop a new final version of these standard contractual clauses. So the situation remains for the time being the same. It is pretty uncertain. If you should already have standard contractual clauses in place, I would at least recommend to document that you did an initial assessment, if and to what extent additional measures could be put in place here. Then I think it's fair to say that it can be waited until we will see this first proposal of the Commission for the adjusted and updated set of standard contractual clauses. Okay, good. So much for the Schrems II verdict. And then I wanted to give an update about relevant GDPR guidance. I think many of you will know that the GDPR is a pretty new regulation. It came into force in May 2018, which means that we only deal with this now for 2.5 years. And a lot of things developed in these 2.5 years. Not that more and more industries had to learn how to deal with these compliance requirements, but also the authorities, of course, entered new territories when GDPR came up. So it was new for everyone. And in the last 2 years, we saw more and more best practice, but also more and more and step-by-step guidance on certain questions from, in particular, the European Data Protection Board. The first thing I would like to refer to is something that we are dealing with almost every day with clients from overseas, in particular from the US, and that is the question about if a company has to be considered as a controller under the GDPR or as a processor, if the relationship between two parties that exchange data has to be considered as a controller to controller relation, which would mean that you have two independent entities with different and individual purposes for processing certain information, or if it rather has to be considered as a so-called controller to processor relation, which basically means that the processor is acting on behalf of the controller. And the third very important category, and sometimes difficult to distinguish from others, is joint controllers, which basically means that two parties are together deciding about the purpose and the means for a certain data processing. And we have seen some pretty new guidance on all these questions from the European Data Protection Board only in September. You can see a screenshot of these guidelines on this slide here. So more information and guidance on the concepts of controller and processor in the GDPR. First of all, when do we have to consider two parties as joint controllers? So the overarching criterion actually is as I already mentioned in the beginning, the joint participation of two, or of course also more entities in the determination of the purposes and means of a processing operation. And that means it does not necessarily have to be the case that two entities are using the same database technically wise. It's not a technical question. However, it can also be technical circumstances. But the key question is, do they determine together? And you see on this slide some additional criterion that makes it a little bit easier maybe to consider if a certain relationship can be considered as, or has to be considered as, joint controllership, or if it's rather controller to controller or controller to processor. So you see that it's about the question if two entities take decisions together, common decisions, or that certain decisions result from converging decisions by two or more parties. Decisions can complement each other and are necessary for the processing to take place in such manner that they have a tangible impact on the determination of the purposes and means of the processing. Or another criterion, the processing would be possible, wouldn't be possible without both parties' participation, in the sense that the processing by each party is inseparable. Joint responsibility does not necessarily imply equal responsibility of operations of the operators involved, which means that the roles and the responsibility can be shared. It's possible that one party has more responsibility and has more to decide for a certain part of processes rather than the other party, but as long as they have the same interest and decide together, not necessarily 50 to 50%, we usually need to consider a relation as joint controller. Let me give you an example for that, and interestingly, that is an example that explicitly is mentioned in these guidelines from the European Data Protection Board. And that is an example from clinical trials. So if a healthcare provider and a university decide to launch together a clinical trial with the same purpose, and they collaborate together in terms of the drafting of the study protocol, for example, the methodology, the design of the study, or the data to be collected and all that stuff, they may be considered as joint controllers because, as the criterion says, they jointly determine and agree on the same purpose and the essential means of the processing. The collection of personal data from medical record of the patient for the purpose of research is to be distinguished from the storage, of course, and the use of the same data for the purpose of patient care, for which the healthcare provider would remain the controller. So that has to be dealt separately. But we might also think about clinical trials or studies where the investigator does not participate in these drafting protocol activities. If that's not the case, if only the other party is the one that determines these processes, then of course we would not consider a clinical trial relation as joint controllership, but as a controller to processor relation. And we have seen a lot of both cases, of course. So cases where we would consider clinical trial as joint controllership, but also cases where the other party is just acting on behalf of the controller and thus would need to be considered as a processor. So it needs to be assessed on a case-by-case basis. Both options are possible, and in order to assess that, it's very important to have a deeper look into the roles and responsibilities in a certain clinical trial. Okay, so if you come to the result that a certain relationship has to be considered as joint controllership, what are the consequences? First of all, it means that you need to determine the respective responsibilities of joint controllers with regards to compliance of the GDPR obligations. In other words, you need an agreement, you need a contract where you define the roles and where you also, and that is the next bullet point here, allocate the responsibilities that need to be done in this arrangement. You also need to organize in the arrangement the way controllers will communicate with the competent supervisory data protection authorities, for example, in terms of a possible consultation of this processing or of this project, if it might be required. That's not the case in all processes, of course. But you would also need to agree on a common process for the notification of a potential data breach to the authority. So what is the role of the parties, who has to provide what information if a data breach should come up. And finally, you need to find an agreement about the designation of a data protection officer. Those are just examples, but it basically means if you come to the conclusion that you have a joint controllership, you not only need to have a fitting agreement in place, but also refer in this agreement to this and a number of additional things that you have to take into account for this special relationship. Okay, so what about processors? For processors as well, the guidelines have prepared some criteria, and again, one overarching criterion that I already mentioned is that a processor is always acting on the controller's behalf. That means he doesn't do a certain data processing for his own purposes or for his own means. He is following a contract, and usually you find situations and relations where a controller is just kind of outsourcing certain processes to a processor because he might not have the technical means or the know-how or whatever to operate certain processes. So he just is looking for someone who can do this better than the controller, and that is typically for a controller to processor relationship. Important to understand in terms of a GDPR definition is that processing is also a very wide array of operations It's not only the classical processing of data, of information. It can be collection, it can be storage, or the consultation to use certain information. It can be the making available of data. It can be the pure access of certain personal information, and also the destruction would be considered as processing. So don't be confused if you read processing under European law. It's by far more than processing from a technical perspective. It can almost be every kind of use or access to personal information. I think that's important for you to understand. And also acting on behalf is important to understand. I already said that this means serving on someone else's interest, and you can describe it as the legal concept of a delegation, actually. And also important, I think I already referred to that, the processor may not carry out processing for its own purposes. Again, it's for the purpose of the controller. And let me give you an example for this controller to processor relation as well. Again, it's taken from the guidance of the European Data Protection Board. So a very typical scenario is IT support and maintenance services. And many of you might know that we also have a lot of those relations with regard to medtech companies. So if you sell or rent or lease a medical device to a client, you might also have in place a service contract that is obliging the licensing party not only to provide certain software or hardware for medical purposes, but also to add additional maintenance services, support hotlines, technical maintenance of certain devices and hardware. And if that is the case, and if the servicing company is accessing personal data by its services, that in many cases has to be considered as a controller to processor relationship as well. And the important thing is that the access to personal data does not necessarily have to be the main object of the support service. If you just occasionally or in the course of the service that you provide can access this personal information, that already is enough, and you would need to consider this relation as a controller to processor relationship. So again, what is the consequence? If you come to that conclusion, what does it mean? Similar to a joint controllership, the main consequence is that you have to put in data processing agreement in place. So a written agreement that has to be concluded between the parties, and which sets out the instructions that the controller is giving and that the processor has to follow. And it's important, and that's why I mentioned this additionally here in the first bullet point, that the duty for the processor to refrain from any processing activity not based on the controller's instruction also applies to transfer of personal data to a third country. So if you have an international or overseas controller to processor relationship, let's say the controller is based in the United States and the processor is based in the European Union, or the other way around, this international processing has to be considered in this agreement as well, of course, which doesn't make it easier if we recall the verdict of the European Court of Justice with regard to international data transfers that I was referring to in the beginning. So again, in this scenario, you would need to take this verdict into account as well. So what else? The processor must ensure that persons authorized to process the personal data have committed themselves to confidentiality, a very important point in particular with regard to health information. You will see the other bullet points here on the list. I will not read each and every point to you, but one of the important things that we always see to be subject of negotiations between two parties in that regard is, for example, the auditing rights under the GDPR in a controller to processor relation. The controller has the right to carry out audits in order to investigate if the processor does comply with certain technical and organizational security measures. And there is some room for negotiations, of course. You can phrase such an audit right more processor friendly or more controller friendly. And that is something that we very often see as a subject to sometimes controversial negotiations between two parties in these scenarios. Okay, so much for controller to processor relations and the current guidance
Oliver,
from the, yes.
in fact, we have a question.
Yes.
Just before you go on to the next slide.
Exactly.
It's quite long though. So the changing status of the EU privacy law has been a constant issue for clients having US and UE interests. Everyone wants to be proactive where possible. One of the most often articulated problems has been how to install adequate compliance system when one has to rely upon so-called safe harbor practice that inherently acknowledge that the underlying legislation is too broad and must be fixed by artificial carve-outs. Do you, in your personal opinion, think that we have now reached a peak in EU privacy law restriction, or if you believe that there may be further restrictions, and if so, where? Also, what do you expect with respect to UK approaches given the Brexit process?
Wow, that's a really long one. Let me try to take that. So first of all, with regard to a potential peak, or if I would expect to that we will even see stricter regulations. Well, in terms of legislation, I would say we currently see more a trend for more flexibility. And we have seen that a lot of companies are struggling with GDPR compliance, and that there is a lot of uncertainty, and that in particular, the industry is calling for a more flexible approach. I'm not sure if that voices will be heard. It's an ongoing process. On the other hand, of course, there are consumer protection authorities, NGOs who call for even stricter rules and stricter requirements. But my personal view really is that I would not expect things within short notice to become even stricter. Then the other part of the question, I think, related to additional safe harbor measures. So the safe harbor, I guess that refers to the privacy shield. The safe harbor was the solution we had in place before the privacy shield. I expect, and that has been announced officially by the Commission, and I also heard it from the European Data Protection Board, that there will be guidance on what kind of additional measures are suitable and can be used in order to translate this verdict of the European Court of Justice into a compliant international data transfer agreement. I think that will come up in the next weeks, or at least month. For the time being, and I think I referred to that, everything around encryption is very important. But I agree, of course, that it's hard to imagine an additional measure that is, well, really the right way to tackle the concerns of the ECJ with regard to the US Surveillance and Monitoring Act and provisions. That's contradiction to each other. But I think we will see further guidance in that regard pretty soon. And finally, and maybe in addition to that question, the US administration and the European Commission are already working on a new political solution, so on a new privacy shield, so to speak, that hopefully meets the expectations of this verdict. and that can hopefully provide another solution as well. I have no idea what the solution could look like, but I know, and that's what we hear from the European Commission, that they are in very intense negotiations and discussions with the US administration, because of course everyone is aware that international data transfer is key to many sectors, to many industries, and that the answer to the Schrems II verdict cannot be to have pure data localization and never again transfer personal information from the European Union to other third countries, right? That's not a solution. Everyone is aware of that. And I also heard the Commission confirm that they are not going for any data localization laws as a political or legislative answer to this decision. I hope this answers at least parts of the question.
Yeah, the last part of the question was also, what do you expect with respect to the UK approaches given the Brexit process?
Yeah, so what we see now and what we expect is that the UK will kind of transition the GDPR into national law. So it will probably be maybe not the identical, but a very similar legal framework, and that will also count for international data transfers. That is not fixed yet, but that's what our expectation is. So that would mean that the Brexit implications from a data protection perspective are handleable. Now, there will probably need to be some things to be fixed in terms of documentation of processes, in terms of international data transfer, because of course, even if we have a similar framework, the UK will be a third-party country from January 2021 on, and that needs to be covered. But everything that we see so far looks like it will be a pretty harmonized legal approach compared to what we have in the European Union. Good.
Thank you.
Thanks for the question. Okay, another update on guidance from the EU. This is not pretty new, but I thought it would make sense to at least very briefly refer on this guidance from the European Commission on EU clinical trials regulation. You might be aware of the fact that we not only have to deal with the GDPR in Europe if we are processing personal or health information, but there's also a clinical trial regulation in place. And when the GDPR came up, that led to a lot of confusion in terms of what applies, where do we have overlap, and how do companies have to take that. And so the questions and answers on the interplay between the clinical trial regulation on the one hand side and the general data protection regulation on the other hand side has been briefly subject of this guidance. So the key statement basically is that the clinical trials regulation requires the sponsor and investigator to process data in a way that it can be accurately reported, interpreted, and verified while preserving the confidentiality of the records and requiring appropriate technical and organizational measures. So in other words, the CTR does more deal with compliance from a research and scientific perspective, whereas the GDPR, of course, has the protection of personal data from the perspective of fundamental rights in its focus. And the important information is that these two regulations apply simultaneously, so you have to make sure that you take care for both if you enter into clinical trials under European law. Then the legal basis for processing and scope of clinical trials is addressed. You have basically two categories here. Processing for safety-related purposes is something that can be based on a so-called legal obligation, which is one justification under the GDPR. So with regard to security processing of information, you do not necessarily need the explicit consent of a data subject, other than for the research activities. So when it comes to real research and the scientific part, not the security part of a clinical trial, consent is required. In some cases, there might be alternatives, but that is very strict and very narrow. So for example, if a certain study is carried out in the interest of public health or for scientific research, but only if national laws, not the GDPR, provides for that. That is important to know as a general information, that the GDPR provides for a number of so-called opening clauses and refers back the legal answers to lawful processing to the national level and opens up for national regulation. That is kind of contradicting the harmonizing approach of the regulation actually, but it's a fact. And if a national law provides for processing of health information for scientific research without consent, then that is of course possible as far as we see, and the member states are very rarely making use of this opening clause. So the rule more or less is really that for research activities you need explicit consent of a patient. Just for the sake of completeness and the last bullet point of this slide, also the European Data Protection Board has published an opinion on the interplay between these two regulations. So if you want to dive even more into the details, it could be worth to have a look into that as well. But it just doesn't say anything that would be contradicting this guidance from the European Commission. Okay, and then, well, very current information with regard to the pandemic situation we are all in currently. We have seen some guidance of the European Union for the processing of data concerning health for the purpose of scientific research in the context specifically of the COVID-19 pandemic. And they explicitly stated that member states can, of course, enact specific laws pursuant to one of these opening clauses that is referring here to in Article 9 of the GDPR, which would be processing for reasons in the public interest to enable the processing of health data for scientific research purposes, of course, in order to fight the pandemic in an effective way. So a very timely reaction on the unprecedented situation we are currently all in. And it was also stated that in the absence of an adequacy decision or appropriate safeguards, controllers may rely upon some derogations that we have in the GDPR, namely in Article 49. However, these derogations have a very exceptional character. That is important to understand. Exception here is really an exception, but at least it has been referred to that the corona pandemic could lead to special situations in terms of scientific purposes that might justify certain data processing for these scientific purposes without consent. Again, a very narrow exemption. Okay, then we come to the final part of the presentation, GDPR enforcement trends in the medical sector. I think, Heather, you already said something similar for the US market. We see more and more enforcement in Europe. We see much more awareness of the authorities and see authorities being much more active than in the past. Whereas, well, maybe in the first year after the GDPR came into force, this was seen as an unofficial grace period by many authorities times have really changed now. We see more and more investigations. We see more and more fines, and we see more and more cases. And as you probably all know, the painful thing with the GDPR is that these fines can be extremely high, and they can be up to 20 million euros, or what is even more painful, up to 4% of the global annual turnover of a company or a group of companies. And that's really the mechanism that can lead to these sometimes extremely high fines that we have seen in some cases, not necessarily with regard to the medtech, pharma, or life science sector, but I have, at least not to threaten you, but for terms of information and transparency, picked out some recent fine decisions that have dealt with the medical sector in a broader sense. You see them on this slide. And the interesting thing really is that if we take a deeper look into these investigations, and that's a general thing, but it's also important for the medical sector, I think, that the authorities investigate very much into the security measures from a technical perspective that companies take in order to protect personal data and health information. And that is one of many requirements under the GDPR. And if you do not have security measures, technical security measures in place, that's really something that seems to be part of a number of investigations and a factor that seems to increase fines, actually, because it's not only a requirement, but also the expectation of the authorities that if you deal with sensitive information, or the more you deal with information that are likely to put a risk to data subjects in case of a data breach or an infringement, the more is the obligation to have security measures in place. So that's really important. GDPR requirements are not only about documentation and transparency, they are to a pretty broad extent really about technical security. And I think all these cases here were related to these technical security measures. So please keep that in mind, that GDPR compliance is by far more than policies and documentation. I think that was my last slide. Thank you for your attention. I hope this was helpful information. I know it's pretty complex, in particular from a US perspective, but maybe I could at least shed some light on these very difficult data privacy questions. Thank you.
Well, thank you everyone for attending today's webinar. If you have any further question, please don't hesitate to contact us. Just a short reminder after you leave the webinar that there will be a short survey, and we would really like to have a short feedback or appreciate your feedback. And Oliver, if you could click on the next slide, sure, please. We just like to point out that we have 3 more webinars on this topic of healthcare. So if you'd like to join us, we would welcome you very much. Thank you very much, everyone, and have a good day or evening from wherever you are listening at the moment. Thank you.